Good morning, sir. Are you Jorge Kazana?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
No, Your Honor.
Mr. Kazana, in cause number 25 DCCR 1472, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from September 28th of 2025. And how do you plead to that charge?
Right away, this case takes a serious turn. Aggravated assault with a deadly weapon is no minor charge, it's a second-degree felony. Notice how quickly the judge moves to confirm that the plea is voluntary. That's one of the most important moments in any criminal case because once a guilty plea is accepted, reversing course becomes incredibly difficult.
Are you pleading guilty freely and voluntarily? Are you pleading guilty because you actually did what they charged you with? Spit your gum out in that trash can right over there. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number
No
1.
objection.
It's admitted. Is there any evidence that Mr. Kazada is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing.
Did you catch that? Even though the defendant just pleaded guilty, the judge isn't sentencing him today. That's because the court wants a pre-sentence investigation report first. Think of it as the judge gathering the full story before deciding the defendant's future. It's a reminder that sentencing isn't just about the crime, it's also about the person standing before the court.
You need to stop on your way out of the courtroom today and talk to probation before you leave. She's sitting at that desk right over there. All right, we'll see you back at sentencing.
Judge, I'm sorry to interrupt. Would you mind just please admonishing him as to the no contact being still in effect?
So I do want to make sure you understand, as a condition of your bond, you are to have no contact or communication with Veronica Panilla. You understand? Nothing. Okay, just make sure you say that, continue that, okay? All right, we'll see you back at sentencing. Thank you. Calvin Smith.
The Philip case.
Good morning, sir. Are you Calvin Smith?
Yes, ma'am.
Will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
Now we move into a completely different case, but the stakes are just as high. This defendant is facing not 1 but 2 felony charges. Whenever multiple cases are handled together like this, the court has to carefully balance accountability with the possibility of rehabilitation. Watch closely because the outcome here could dramatically impact his future.
Mr. Smith, in cause number 25 DCCR 1638, you're charged with the state jail felony offense of burglary of a building from September 30th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
Then in cause number 25 DCCR 1639, you're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from September 30th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement in the state jail felony offense is for a 5-year deferred probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Y'all didn't mark a term of years in the
Five.
second.
I'm
It's
sorry.
5 as well.
I know I did. That's weird.
And then in the evading case, it looks like the agreement is the same. For a 5-year deferred probation, there would be a $1,000 fine, and you'd again be required to follow all of the rules and conditions of probation. Is that your understanding also?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Smith is not competent?
Your Honor, he is competent, but I just want for the record for probation, as a result of this, he had a traumatic brain injury, so he has problems remembering things. And
Okay.
so I thought that'd be taken into consideration when
All
I
right.
talk to him.
This is a detail you never want to overlook. The defense attorney just informed the court that the defendant suffered a traumatic brain injury affecting his memory. Legally, that doesn't automatically make someone incompetent, but it can absolutely influence how probation officers and judges evaluate compliance, treatment needs, and future supervision.
They'll make a notation of that as well. All right, Mr. Smith, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll just give me this information about you and your cases, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right behind you, okay?
Yes, ma'am.
All right, we'll see you back at sentence.
Okay.
Thank you, Mr. Parker. Yeah,
Here.
what did I do on Mr. Rojas's William Bonilla? Oh, that's right. I just didn't make a notation on that one. Ms. Holmes, you've got Devon Murray. It's a sentencing.
Yes.
Good morning. Good morning. Are you Devon Murray? Speak up.
Yes, ma'am.
And this is cause number 26 DCCR 0346. Mr. Murray was previously in court, entered a plea of guilty to the second-degree felony offense of robbery. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
Not from the defense, Your Honor.
There's the only thing I have, just more for the court's knowledge than anything else, with respect to the statement of the interested party. The co-defendant in this case is Jose Lugo, who's also before this court. I've just ask you to take that into consideration when you see that case coming.
I mean, you guys both read the recommendation of ISF. correct?
Yes, Your Honor, and I've spoken with Mr. Murray, in regards to that. I did tell him that I would ask the court to hold it in abeyance if possible to see how if he can get started with probation. But he does know that that is, a decision for you and, whether that will be held in abeyance or not.
So it's not going to be held in abeyance. So you're young.
Here's where this hearing becomes especially interesting. Many viewers hear the words probation and assume someone is simply walking free, but that's not what's happening here. The judge is about to explain why an intermediate sanction facility commonly called ISF is being used as a tool for rehabilitation rather than pure punishment. The next few moments reveal exactly how courts try to reduce repeat offenses.
This situation of, I mean, the whole point was buying and selling guns, and that's just a big problem about what's going on right now. And so ISF is not necessarily meant to be a punishment. It's meant to give you some tools. You're very young, so that when you do that program and you get out, you can be successful on probation. Because what I don't want to do is put you on probation, not give you those tools, you mess up, and then come back in and go, well, don't revoke my probation, send me to ISF. So I'm going to send you now. You're going to get those tools. Then if you mess up, it's going to be even worse. You understand? All right. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That will include entering and successfully completing the cognitive track of the ISF program. You are not to have any contact whatsoever with the co-defendant, Jesus Lugo, and also with the victim, Kiera Davis. Do you understand? And that obviously means contact in person, but it means any type of communication through electronic media or Snapchat or any of that kind of stuff. You understand? You'll be on the high medium caseload when you get out of ISF. That's also to help you get started on probation and to be successful. This is an excellent opportunity for you because you don't have a felony conviction on your case, on your record. And if you successfully complete the probation, then you'll never have a felony conviction. You'll be able to go on about your life like the rest of us without being a convicted felon. The other side of that, though, is if you violate any condition of probation at all, you can be brought back into court. You could be found guilty and you could go to prison for anywhere in the range of punishment, which is between 2 years and up to 20 years in prison. Do you understand?
Listen to how direct this warning is. Deferred probation can be an incredible opportunity because a successful completion means avoiding a felony conviction. But the flip side is brutal. One serious violation could send this young defendant back to court facing up to 20 years in prison. It's a second chance. But it's also a very thin tightrope to walk.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. Also, I want to make sure you understand, Mr. Murray, you're going to go into custody today. You'll be in our jail for just a couple of weeks, probably. I don't think there's a big waiting time to get to ISF. But while you're in our jail and while you're at ISF, it's part of your conditions of your probation now that you follow all of the rules and be courteous and treat everyone that is working there with respect. So don't go get in our jail and start getting involved with some of the people out there that are not doing that. If you get an incident report while you're in jail before you even go to ISF, it's a violation of your probation and you can never get out again without me revoking your probation. You understand? All right, you can go back with the bailiff. See, Francisco Garcia.
3 defendants, 3 very different circumstances, yet every case highlights the same reality of the criminal justice system. Accountability, rehabilitation, and consequences all collide inside the courtroom. The opportunities handed out today could change these defendants' lives, but only if they choose not to return to the very courtroom they're walking out of.